Thank you very much. Good afternoon, good evening, and good morning, wherever you're listening to. This is the second episode of our Seeds of Justice webcast, brought to you by the Asian Research Institute for Environmental Law and the Asian Development Bank Environmental Law Champions. My name is Matthew Baird. I'm the director of the Asian Research Institute for Environmental Law, or as we call us, ARIEL. So welcome to you on YouTube or on Facebook, and it's great to be with you this evening. And so today we have the first of our case note episodes where we're going to look at a particular environmental law case, one of the really important ones within the Asian region, and talk to the attorney who was one of the co-counsel in bringing this case, and discuss some of the issues. And the case is the resident mammals, start that again. The resident marine mammals of the protected seascape Tañon Strait are represented herein by human being Gloria Ramos and Liza Osorio in their capacity as legal guardians of the lesser life forms and as responsible steward of God's creations against Secretary Reynes and others. So I'm great pleasure to introduce our guest tonight, Liza Osorio. She is a professor of the University of Cebu School of Law, teaching environment and natural resources law, international environmental law, property law, administrative law, amongst other things, for the past 17 years. She is currently the chairperson of the governing board of the IUCN Academy of Environmental Law. She is the first Asian academic to head the IUCN Academy. She's also a member of the steering committee of the World Commission on Environmental Law and the Environmental Law Alliance Worldwide. She is a co-founder and previously the managing trustee of the Philippine Earth Justice Center, and through PEJC, several environmental cases were filed in the Philippines, including the landmark case of resident marine mammals and dolphins against Secretary of the Department of Energy, where she was one of the two lawyers who recognized the Supreme Court as the human stewards of the whales and cetaceans of the Tañon Strait protected seascape, one of the largest marine protected areas in the country. She recently joined Oceana as its legal and policy director and works on strategic directed campaigns in the Philippines to ensure protection of oceans through science-based fishery management and policy reforms to stop overfishing, habitat destruction, and marine pollution. And it's a great pleasure to welcome Attorney Liza here. Hi, Liza, how are you?
Hi, Matthew. Good evening, everyone. Good afternoon, good morning to those not living in the Philippines. But generally, I think for the Filipinos listening to us, good evening or maayong gabi in Cebuano.
And I do like the Cebuano, and indeed it's probably been one of the things that's really been a big feature in the work that you do in terms of protecting the oceans and the seascape. So I'm just wondering, can you give our listeners a little bit of an introduction about yourself? We've heard about, obviously, your extraordinary academic achievements and the work with the IUCN Academy of Environmental Law, and of course as one of the ADB's environmental law champions and a great supporter of environmental law and environmental law academics. But you're also a litigator. So what are you? Are you just everything?
I guess I'm the jack of all trades or the Jill of all trades, I guess. Yeah, but I'm lucky that I live in the Philippines. I think similar to you, Matthew. In the Philippines, you can be an academic, you can be a litigator at the same time. So it's not like you're just, put in one silo where you just become an academic and do just academic research and teaching. But in the Philippines, we're lucky that we are allowed also to practice. And so, but most of my time since I became a lawyer has been really focused on environmental litigation, environmental law advocacy also. So I guess I have the best of both worlds, as you can see. And it allows me to also delve into research or in environmental law in the Philippines in order to advance it, and by teaching, it also allows me to train or to train future environmental law champions that and mold them to become environmental litigators, in the future.
So I know that both you and Attorney Golly, who
Yes.
brought this case, who can't be with us tonight, unfortunately, you've run a number
Mhm.
of cases. And tonight, we're going to focus a little bit on this resident marine mammals case. And I mean, it was decided, I think, in 2015,
15. 15.
but, but you commenced the case in 2007.
Yeah.
So I guess one of the things that really interests me is what made you think about bringing a case in the name of the resident marine mammals
Mhm.
and the why
Well, I
on
guess.
the name?
Sorry. Yeah. Well, I guess the site where the activity was held was actually the one that suggested to us that it is very important to bring the case in behalf of the residents there, living in that marine protected area. So the site I'm talking to you about is the protected seascape of Tañon Strait, which is, a very important migratory area for dolphins, whales, and other cetaceans in the Philippines. As mentioned in the introduction, it's one of the largest marine protected areas. It is actually, located between two big provinces in the central Philippines, which is Cebu and Negros Islands. And so it's a very deep water body. That's why I guess it's the favorite playing ground of these resident mammals and dolphins. And so when we heard about the oil exploration activity, we immediately thought about ways on how to stop it. And of course, we had with us so civil society organizations, concerned citizens as well, and of course marginal fisher folks who were very concerned about these activities that were occurring in this marine protected area. And given that they were conducting seismic surveys for oil exploration, and later on, they built also a structure in one of the local government units here in Cebu, a platform to explore further into one of the sites. And so, because of the danger, we knew that there was a danger with the seismic surveys because they were using sonar to the wildlife species there. We thought about bringing the case in behalf of them because we know that at that time, not sure about now, but at that time, we knew that the Philippines were really very, I guess, path breaking or very innovative when it comes to hearing these cases in a way that our Supreme Court was, I guess, in at the forefront of making innovations when it comes to deciding environmental cases at that time, because we had Oposa versus Factoran case, and so we relied on that, you know, um, very judicial activism, as you may say, at that time, and so we wanted to further stretch um, the discourse, the legal discourse on standing for in environmental cases. And so, yeah, that's when we decided to bring it in behalf of the marine mammals and dolphins.
And so there were a couple of cases, as I understand. So there was a case which was run by the fisherfolk. You, of
Mhm.
course, also there as stewards. Is that correct? You were
Yeah.
acting, so that you brought it on this idea of the the the, the whales and cetaceans themselves, but
Mhm.
also as you as stewards or guardians.
Yeah.
Um, and and it was a case where the Tañon Strait had been already protected. It was a special seascape
Mhm.
area, and so there was oil exploration going, and I think there was meant to be you were challenging, I think, a contract under
The
that was
service contract.
a service contract issued by the president. So, or meant to be issued by the president. So, in terms of the particular outcomes of the case, what do you think was the thing that makes this case such a sort of a successful public interest environmental case?
Yeah. Well, it was It was filed at a time when the environmental rules of procedure was not were not yet promulgated by the Supreme Court. It was in 2007, and the rules of procedure for environmental cases was promulgated in 2010. So it was actually at the time where we were still guided by the ordinary rules of civil procedure in the country in filing special civil actions like this. And and so that's why we decided, by the way, to file two cases, because amongst our group, we had like the traditionalists, you have to file a case where you have your locus standi is based on the injury, the wreck and personal injury, which is the marginal fisher folk. So, and then you also have this case where we're trying to challenge the norms of locus standi, allowing nature to file case, the animals to file the case and have standing in court. So that's why we brought the case together. And um, and yes, so it was quite an exciting time for us because we wanted to challenge really the prevailing legal norm of the traditional local standi that was recognized at that time. And as the case was decided, it was although uh, the Supreme Court dodged the question that we really wanted to them to answer, which was to give legal standing to the resident mammals and dolphins. But they dodge it by saying that, well, at the time when they promulgated the case in 2015, they said we already have the rules of procedure which allows for a citizen suit. And the legal representatives of the resident mammals and dolphins could now be considered as the stewards of nature, and so they can have the standing to sue in behalf of the resident mammals and dolphins. So I guess they dodged really the main issue, and we wanted them to go beyond that. But well, but it was still very important nonetheless, because it was the first time where any citizen could become a steward for the environment, right? And can file a suit in behalf of nature.
And I think this is where, this type of case can be really quite challenging to judges, because at its core, it was some lawyers acting on behalf of clients, non-human clients, but also as stewards. So there was that dual position that you took. But you're also challenging the idea of issuing a license or a service contract in the protected seascape of the Tañon Strait. And I think the court was extraordinarily strong on saying that this was not possible because the seascapes were created by Congress, and therefore only Congress could allow this type of service contract or oil exploration or oil drilling in that area. I mean, that was a huge win, I think, just on that alone, because I think this really has had a big impact also on all of that sort of ideas about offshore mining.
Mm-hmm. Yeah, true. That was the real substantive issue that we won in that case. And, basically what we noticed, because the government, pounded on our attempt to have the locus standi recognition for non-human petitioners, they did not dwell so much about, in their briefs, they did not put so much attention on the service contract argument, maybe because it was really a losing argument on their part, because they knew that there was a really strong law on protected area, the NIPAS law, which really disallows, service contracts. But it was a real win for us in terms of that, that, essentially, you cannot allow service contracts, but because, as you said, that would be against the Congress imprimatur itself on declaring such as a protected area.
And I think, when you look at the case, and I want to come back to the standing question, because I think it was really interesting to see how the judges were obviously, a little bit troubled by those claims, which is quite exciting. It's always good to challenge Supreme Court judges. Um, but in terms of the issue of the service contract and the National Integrated Protected Area System, the NIPAS, I mean, it was a very strong judgment that really supported marine protected areas. And I think this is really one of those important decisions, given the discussion we've had about deep seabed mining. Even though this has occurred in 2015, so quite a while before we've now faced this. I mean, there was a case just recently today in the New Zealand Supreme Court where they rejected a deep sea mining application within New Zealand. And I think this is going to be a big challenge, certainly to the Philippines, but I think to sort of Indonesia and Malaysia as well, in terms of people trying to exploit protected areas. Yeah. So I think that's also a sleeper decision, in that it's a really powerful argument for protecting these marine seascapes in these marine areas. So that was also quite interesting.
True, yeah. The impact of this case, we guess, was really to disallow, service contracts being allowed in protected areas. At least now we have a very strong precedence that would set that tone, as you said, that sleeper doctrine that we could use anytime when there's a proposal for seabed mining, or what our problem nowadays also seabed quarrying. So if it's a protected area, it's a no-no, because we could use that decision, and that's good, right? So our challenge now is really to ensure that people know, and thank you for pointing it out, because people really sometimes forget about that part of the decision, where they always focus on the locus standi part of that case.
And look, I confess, I've been mostly focused on the locus standi and the way the court, and then rereading the judgment, I'm thinking, wow, this was really quite powerful. I mean, also, I think it was quite powerful in terms of working out, whether I think a service contract had to be, signed by the president. There had to be clear procedural correctness in these sort of issues, and that again is another very strong judgment to say, if you get these things wrong, they will be overturned.
Yeah.
But getting back now to the standing issue, it was commenced in 2005, and look, I've been an environmental lawyer a long time, so I look back from 2005, and this is a judgment, or this is a cause of action, or an argument that's innovative now. 15 years ago, 17 years ago, this was really, and the judges, I think, had some challenges. What was it when you said, we're bringing this case on behalf of the resident marine mammals?
Come again? What is?
What was it like in terms of in court before the bench? They were out when you were saying, "Well, I'm here on behalf of the dolphins and the whales."
Well, we could admit that a lot of people laughed at us, even like the lawyers, like, okay, that will never happen. They were really, we were really seen as something of, an odd group of people trying to bring something to the court. And we could see also that, as you said, in the discussion of the court, they really had a hard time, dealing, or, neatly dealing with, the arguments that we brought before them. And in fact, I'm very interested in really also trying to look into deeply more into their argument, which was quite scant, as you said, in terms of really, our expectation of them really trying, would have had, made it more comprehensive, I guess, when they discussed that. But it was very, there was a very, a line or a paragraph even just to discuss on the main opinion, that is. But you could see that there was a separate opinion by a justice which really tackled it more. But as I said, my interest is in really looking at how they the main ponente decided the case, and she said that that we could become as stewards of nature. We could act in behalf of the dolphins, and so it's obvious that if you read the works of Christopher Stone, it was precisely what Christopher Stone was really trying to advocate, right? That the guardianship approach for nature. It's possible to for nature as non-humans to become plaintiffs by themselves or for themselves, and they can speak in their own behalf and using the guardianship approach. And in fact, by reading that, for me, I think that the Supreme Court adopted that guardianship approach, and so that could, I mean, I'm really trying to make and hopefully that there would be more cases in the future that would challenge and bring, and the court will have the opportunity to discuss it more. Hopefully not to overturn the earlier decision, but to put in more flesh to what they pronounce in that case. Um, and as because again, that would really bring at least more clarity as to really how citizens, how ordinary people can become guardians of nature in this jurisdiction.
And I guess, like you, I read that judgment, and it went back to the previous rules that said, well, it has to be a natural or judicial person, so a legal entity, and in which case you sort of say, well, if a corporation can bring a suit, why can't any other creature or tree be given legal standing? It's just it's just a construct. But I did also think when I read it, well, in fact, they were saying someone could bring up, as the stewardship argument runs, and as lawyers, I think we also know that nature, in and of itself, may have challenges in bringing its case to court. You do need people who are going to interpret and proffer, but it does recognise that the whales, the cetaceans, and presumably by extension the Tañon Strait itself had some intrinsic value that,
Yes.
irrespective of what we were going to do with it, you as a lawyer, as an attorney, or as a steward, could bring that case to court. And so I thought that also was quite interesting, although I don't think, as you say, the court didn't grapple with it very clearly. Other
Mm-hmm.
judges, maybe opposer and factorum, were maybe too broad. I don't know. But it certainly seemed to adopt that argument that
Mm-hmm.
has been put in Trees Have Standing. Not that the tree should come into court, but there should be someone on which they can make
Speaking on their behalf. Yes. Yeah.
it was interesting. And so I was wondering whether or not that was something that, and they mentioned that a ship, for example, is accepted as a plaintiff
As a
or a defendant.
person, a legal person, right? A corporation, we've done that, like minors, even be incapacitated, all these things have been advanced. And I think it, as you've seen, this always started with someone trying to challenge what is the prevailing norms, the prevailing doctrine. And I guess we could not be far behind that, in the future, where we can really have that recognition. And in fact, I know that there are some um, um, proposals now for a law to to recognize the legal personhood of nature. There's a right of nature movement in the country, and they're preparing a proposed law where Congress would recognize the rights of nature. So, it always starts with something, an idea, right? Before you can have a revolution. And I guess with what is happening around us, climate change, the importance of protecting our biodiversity because of the massive losses that we are having when it comes to marine and, terrestrial biodiversity. I think we need that forward thinking. It's even, as you said, I think the rights of nature approach is really an ecocentric approach in trying to grapple with all these issues that we're facing, and preserving nature, not using the anthropogenic lens, right? So the anthropocentric lens, and I think people are starting to realize how important nature is for us.
And certainly this idea of seeing nature through that ecocentric lens, seeing litigation on behalf of nature, not just because it impacts on humans, I think is going to be one of these huge challenges. I know we've had, and indeed I think on this Friday, the Human Rights Council is going to vote on a resolution to identify or a human right to a safe environment. But I think we all would say, well, yes, there should be a human right to a safe and healthy environment, but there's also an intrinsic value and right of the environment, of ecosystems, to protect their integrity, even if that creates some conflict with humanity. So I mean, it's and this sort of judgment, I think, really was certainly quite visionary. I did want to ask that the case was commenced 17 December 2007, and judgment was handed down on the 21st of April 2014. That's and indeed, as I also understand, the service contract had been abandoned or finished. But that was also another important point that the court did. It just said, well, just because the subject wasn't determinative, it didn't mean that you shouldn't actually go and adjudicate on the very important basis. And I thought that was also quite interesting, because they could have just dismissed it on the basis, but that the contract was no longer there.
Yeah, it was smooth and academic, but they did not. They even said they had this is a retroactive application, this decision, which is also very important. So that you could really find so many important things there. And I guess we were expecting really the court to rule immediately. Well, we kept on hearing that that they would be ruling soon our case, but it took them, I guess, 7 years to finally come up with that decision. So I guess it was really something that they had to really, I guess, study carefully, because I think one of the issues raised in the separate opinion by Justice Leonen was that this might result to more cases, a deluge of cases in court if we do this, right? And I guess that's just always been the same argument, the line of argument that we see even in the United States or in other countries where these kinds of cases have been raised. But we don't really see, any other. There was no deluge of cases suddenly happening because of that. Because I think even if there was that recognition that you can become stewards of nature, people were more or less careful of trying to overuse that doctrine in order to forward their environmental cases in court.
We're not like America. We don't sort of wake up in the morning and say we should go to court.
Yes, we're not like that. We're not litigators.
In Australia, I mean, in New South Wales, in 1979, they introduced the Environmental Planning and Assessment Act in Australia, in New South Wales, and it had broad standing. In the Land and Environment Court had a section, Section 123, which was any person could take action to remedy or rectify a breach of the Act. And everyone said, well, that would be the floodgates. Well, the floodgates never opened. There were a lot of public interest litigation, but it never overwhelmed the courts. It never overwhelmed the system, because litigation is not something that can be undertaken too easily. At this point of time, I would actually like to bring in the deputy director. Sorry, I've got a very
we have I guess there non-human potential petitioner.
And so Rocky Guzman is the deputy director of the Asian Research Institute for Environmental Law and a former Oceana lawyer. Thanks, Rocky. Yes. I wanted to sort of bring you in and say, okay, this case, it started in 2007. under old rules. And then we had the 2010 Supreme Court procedure in environmental cases. Did you think that this case had was an impetus for the court to develop special rules of procedure in environmental matters, or were there other factors at play?
Yeah, I think it could have been a factor, but I'm proud actually of the Philippine legal system that it's been traditionally, I mean, even before this case, it's been more or less or relatively revolutionary or compared to other jurisdictions. So even before the resident marine mammals case, we already had the Oposa versus Factoran doctrine, the intergenerational responsibility a few decades back. And then even before the rules of procedure for environmental cases, the court already issued a writ of continuing mandamus for the protection of the Manila Bay through a case in like 10 years before the rules of procedure. So I think this all led to that point. I mean, the justices and the judiciary were already exposed to all these concepts and all these doctrines. And I think this case, the resident marine mammals, was an impetus, actually, as you said, to for the Supreme Court to be more innovative. And I think that time was ripe around 2010, 2011 for the court to really institutionalize these rules into the rules of procedure.
So it was more sort of an evolution,
Right.
not the revolution. I mean, we look at the writ of Kalakasan, we look at orders for temporary environmental protection orders, the writ of continuing mandamus, a number of these sort of innovative mechanisms, which we look at the Supreme Court rules, were actually things that had been developed over time, and so it was a codification.
Yes, indeed. And yeah, and it's continuing to evolve. There are so many things that are happening in the judicial system here. Like before the RPEC, before the rules of procedure, we already had those cases. And then we have these, like the application of the precautionary principle in an eggplant genetically modified case, for example. And then there are the prospects of climate litigation even developing more. And then the plastics and marine pollution litigation. So there are so many bright spots in terms of innovation and possible revolutionizing the legal system in the Philippines further.
Yeah, but I think in fact it goes back to the 1987 Constitution, even where we had the recognition of the right to balance and healthful ecology in accord with the rhythm and harmony of nature. I really love that phrase, and
Yeah.
that even that where we if you could go into deeply more deeply into that phrase, we recognize the people's right to an environment, healthy environment, but also at the same time, did we recognize also nature, that we have to coexist with nature, right? We have to be in harmony with nature. So the framers of the 1987 Constitution were really very revolutionary in a way, because of they put that into the Constitution itself. And later on in the Oposa case, it was declared as an enforceable right. And so that became very, very important, established as a doctrine.
So, and look, I mean, on that, I've heard Justice Azcuna talk about the constitutional changes, where people even then were worried about giving sort of people a right to a healthy environment. The Philippines seems to have coped quite well with its 1987 Constitution. Obviously, there are always challenges. But from that environmental law perspective, I mean, do we think that there's going to be potentially more litigation on what that means? Litigation with respect to climate justice, for example? I mean, the rhythm and harmony is clearly that we're losing at the moment.
Yeah, I think there would be more. It's just that I think I asked this question last week during the training of environmental law teachers, because I see that for the writ of nature, which is really another very important action that we have been that has been often used nowadays by environmental litigators. But we do see some sort of regression, because the Supreme Court has become very strict when it comes to interpreting the three requisites that have to be there for them to issue the writ in how many cases that we've seen so far. So in fact, many people are now getting frustrated because, Supreme Court seems to just dismiss case after case when it comes to the writ of nature or writ of kalikasan, because they said that, we have not proven damage, we have not proven, scientifically, even if we have the precautionary principle. So I mean, it's also, I guess, very challenging right now, based on our experience, to use the writ of kalikasan or the writ of nature. But I see that people are still trying to file, trying to address this environmental issues that they're facing, and using the last resort to with the courts, in order to address these environmental issues that we have.
Yep.
So yeah, sorry, Rocky.
No, I think exactly. Once we address all these issues, we have the potential to really open more opportunities for litigation. It's just that we need to address like the institutional issues first of all. Like some litigants and some lawyers and some members of the judiciary have to know more about these remedies, and then addressing that science and law interface where you have to establish causation. You need to have establish more science and interfaces in that respect, and the overall enabling environment that we need to have, not just the access to remedies or access to justice, but also the accompanying access rights, right? Like the need to get more information from the government and to
Mm.
have more a robust system for public participation. It all goes hand in hand with all these, and to really have a good framework for environmental governance in any country.
So, in terms of that future of public interest environmental litigation, I mean, the Philippines is known as a country that has, has had this opportunity for access to environmental justice. It seems that now is the time when we have to reevaluate that and work out how we can recommit. Obviously, now is certainly the time, as the Secretary General of the United Nations in a recent report said, we are waging a war against the environment, which is suicidal. Judges are part of the process we need to access environmental justice. So I guess just in terms of closing up this amazing talk, and I really appreciate the opportunity for you to come on to our show. What are some of the things that you would think about the future of public interest environmental litigation? And I'll ask Rocky to answer that, and then I'll end with you, Liza, about what you might think here. Some of the things that we could do to strengthen, reawaken, re-energize, re-excite the Supreme Court. Rocky?
Sure. Yeah, but I'll go ahead. Just maybe reflect on what Lisa said earlier, that it all started with someone challenging, right, the norms and the prevailing doctrines. And I also believe that we're not far behind, and who knows what the future might hold in terms of legal reform in the Philippines. But that goes back also to my conversations when I was just, I wasn't a lawyer yet, and I was being mentored by, of course, Lisa and Golly through the Philippine Earth Justice Center then, and she said that in environmental law you're not bound by the traditional rules, and you can be as creative as you want. And so if we can reach out to more people, to students, to young lawyers, and we can actually recruit more people into this field, and that the future looks bright if there are many people as involved in this field. And yeah, we're looking forward to more public interest environmental litigation in the future.
Yeah. So for me, I guess with every crisis there are opportunities, right? And I guess we now live in a climate crisis, environmental crisis, so crisis after crisis, and I think it gives this this point in time gives birth to also a number of opportunities for litigation. So in fact, I've been working with different communities who are now seem to, you know, wake up and realize that, they have the right. So even if they're just fisher folks, even if they're just youth, even if they're just a concerned citizen, they can, if they if we explain to them that, these are, your rights, these are the remedies that are available, be given, that concern that you have in your area, and they have been, and there have been like, it seems like a change in the mindset of people that it's possible, I can do these things because but as Rocky said, we need more lawyers, we need more lawyers to assist them, to educate them, and so that's why we need more champions. And working with ADB through the trainers, it's really very important, because we could train more environmental law professors, those professors will be teaching future environmental lawyers, right, Matthew? And so I guess that's a challenge. We need to multiply our group because as there's simply a lot of issues being raised at this point in time, and so the opportunities are there. The legal um, you know, the legal architecture for raising your voices up to the highest level of the courts are also there. We have the rules of procedure for environmental cases. We just need to have more capacity for people to be able to realize their intention of solving at least even just a minuscule or fingertip of those crises that we're facing. Thank you. So thank you for the invitation.
Thank you, Lisa. And can I just say, it's always a pleasure. I know we see each other quite a bit, but and I may be, perhaps too old to have mentors, but you're still one of mine. And so I really want to thank you. And again, thank Rocky for your comments as well. One of the exciting things as part of this Seeds of Justice program is every week we'll look at either an environmental law champion or an environmental law case or environmental law topic. Next week, we have attorney Maria Ipat Luna, who's, again, another environmental law champion, and she'll be talking about her journey and the steps that she's done over the years to advance public interest environmental law and litigation. The resident marine mammals case, again, a case that has certain obvious interests in terms of the lock of standing and the question about stewardship. But when you go into that, it can go into enormously productive and interesting environmental law principles. And I think it's going to be even more grow in importance as we face a lot more challenges, certainly with ocean and ocean protection. It's been a great pleasure and opportunity to speak with Liza today. I can also say that on behalf of the ADB Environmental Law Champions Program and Ariel, we really appreciate everyone for giving up their time and being with us today. Again, this time next week, we'll have episode 3 of Seeds of Justice, and this podcast will also be available on YouTube and on Facebook for your listening pleasure. It's been a great pleasure and really exciting to explore in depth one of the really important cases in Philippine and, if not Asian, environmental law jurisprudence. So thank you very much, and good evening, good afternoon, and perhaps good morning as well. Thanks.
Thank you.
Thank you.